The New York Attorney General.
I am announcing that today we are filing a lawsuit against Donald Trump for violating the law as part of his efforts to generate profits for himself, his family, and his company. The complaint demonstrates that Donald Trump falsely inflated his net worth by billions of dollars to unjustly enrich himself and to cheat the system, thereby cheating all of us. He did this with the help of the other defendants, his children, Donald Trump Jr., Ivanka Trump, and Eric Trump, and former Trump Organization CFO Allen Weisselberg and Trump Organization Controller Jeffrey McConney. Mr. Trump and the Trump Organization repeatedly and persistently manipulated the value of assets to induce banks to lend money to the Trump Organization on more favorable terms than would otherwise have been available to the company, to pay lower taxes, to satisfy continuing loan agreements, and to induce insurance companies to provide insurance coverage for higher limits and at lower premiums. This conduct was all in violation of Executive Law, Section 6312, which gives the Attorney General broad and special powers to go after persistent and repeated fraud and illegality. As part of demonstrating illegality under that section of Law 6312, we show that they violated several state criminal laws, including falsifying business records, issuing false financial statements, insurance fraud, and engaging in a conspiracy to commit each of these state law violations. We believe the conduct alleged in this action also violates federal criminal law, including issuing false statements to financial institutions and bank fraud. And we are referring those criminal violations that we've uncovered to the United States Attorney for the Southern District of New York and the Internal Revenue Service. As a result of these violations, we are asking the court to, among other things, permanently bar Mr. Trump, Donald Trump Jr., Ivanka Trump, Eric Trump, from serving as an officer or director in any corporation or similar entity registered and or licensed in New York. To bar Mr. Trump and the Trump Organization from entering into any New York State commercial real estate acquisition or from applying for loans from any financial institution in New York for 5 years. To pay for the financial benefits obtained as a result of the persistent fraudulent practices at an estimated $250 million. And towards the end of my remarks, I will go into the other relief that we are seeking. At the center of the year-long financial scheme were the statements of financial condition that were prepared annually by and for Mr. Trump, specifically from 2011 to 2021. These statements were compiled by the Trump Organization executives and were issued as a compilation report by Mr. Trump's accounting firm. The statements are explicit that the preparation was the responsibility of Mr. Trump. Or starting in 2016, the trustees of his trust, Donald Trump Jr. and Allen Weisselberg, for the sole benefit of Mr. Donald Trump. Each statement was personally certified as accurate by Mr. Trump or by one of his trustees as part of the loan process. In the statement, Weisselberg would meet to review and approve the final statement every year. Mr. Trump made known through Allen Weisselberg that he wanted his net worth reflected on the statements to increase, a desire Mr. Weisselberg and others carried out year after year. in their fraudulent preparation of the statements. And when asked about these meetings under oath as part of our deposition, both men, Mr. Trump and Mr. Weisselberg, invoked their Fifth Amendment privilege against self-incrimination, and they refused to answer. When asked under oath if he, Mr. Trump, continued to review and approve the statements after becoming President of the United States in 2017, Mr. Trump, again, invoked his Fifth Amendment privilege and refused to answer. Over the course of our investigation, we found that Mr. Trump, his children, the Trump Organization, created and used more than 200 false and misleading asset valuations on his statement of financial condition over that 10-year period. They issued statements that were in clear violation of general accepted principles in the general accounting principles in the United States, despite representing that these statements were prepared in accordance with these principles. Some of the common tactics they used include representing that Mr. Trump had cash on hand that he did not have, ignoring critical restrictions that would significantly impact property values when setting valuations, changing the methodology used to value properties from year to year without reason or notice, and using vastly different methods to value different properties even in the same year.